Just We the People News, not attorney, not giving legal advice. Okay, educational purposes only. Arm yourself with knowledge. Use that Second Amendment, people. Um, Anything I say or do is just my opinion. It's hearsay. Okay, do your own research. All right, so I haven't seen the whole video on this. I just been getting part, as you can tell with the white line there. But this is from Jeff Morgan. People in Texas need to listen to this, especially applies to Texas. However, anybody outside of Texas is actually rammed through the same process nationwide due to the 4D program of the federal contract. Okay, so we got to be aware of certain things that is a cause and effect, right? Um, Everybody don't know these things, and sometimes we have to educate ourselves. When you go to court, you do not have to sign nothing. Even if the judge orders it, you don't have to sign it. Are you, you know, technically, you just kind of say, I'm not here to contract with you. Got previous videos, a few videos back, of a man doing that. And he calls it out. I'm a man. I'm not here to contract. And he never signs nothing. Never has signed anything all the way up to the higher courts. Eventually, him and the woman actually come up to some type of private agreement. Okay? Um, so it came out to be good on that behalf, but it was due to a private agreement. But he was going to still stand there and deal with the situation as a man. Okay, this applies to the women too that have their little issues in family court as well. But here we go. Check this out.
And so I assume there's some.
Mr. Ryder's.
And so I assume there's some standard for making a determination as to whether the parent is fit.
Not really.
That's what I was worried about. That you have a.
Listen to the key words there. Not really. They don't have a standard. And yet, this is what family courts is all about.
You say that, well, a fit parent can make the decision what's in the best interest of the child, but then that raises the question of what's a fit parent.
And I think that's a judicial determination. I mean, from my perspective, you would listen to evidence about what are the decisions the parents been making? How have the parents been behaving? What have they done in and around the child since the child's birth to each other in a relationship? I mean, has that parent made poor decisions in the past that would make the judge determine that they're unfit? And on that topic, one of the other things that I struggle with, and I think we agree on some of the presumptions of that courts should stay out of the way of fit parents who are not doing anything that's harmful to their children, and their children are thriving and they're doing well. Last session, the legislature passed a bill that said if you've been terminated, you can come back and ask to have your kids back and basically be reinstated as a parent. And so these are parents, from my perspective as a judge, if I'm going to terminate someone's rights and I say to them, this means that I have determined that for the rest of your life, you can't parent this child. Because if I thought you could, I wouldn't terminate you. I would do some other arrangement in an order and see, how we go. Well, last session, the legislature said no, even if they've been terminated, as long as it's been an agency termination, if they want to come back within a 2-year period and say, I want to be parent again, that under certain circumstances, the courts have to allow them to make that request and then make a determination. And so we've already determined they're not fit. And we're still going to let them come in and say, okay, well, I've got my act together. Do parents get their acts together?
Now that begs the question, right? What is a fit parent? And how did it get a judge to determine how a fit parent is and determination of the parents? And, you know, and these are hearsay for the judges anyway, on the record, but it's still hearsay. The judge has never actually ever seen the household and how it was ran or anything. And you got two people, two attorneys or two people bickering back and forth, and both sides allegedly relying on one another, and yet they got to make this determination without a specific way of what is a fit parent. I mean, the idiotic thing about this is they don't even have a guidelines by it.
Absolutely. But at some point, there's got to be some finality. And so I think that statute that went into effect last September has sort of turned the parental presumption issue on its head. We don't give them the presumption of being a parent, but we certainly let them come in the door and say, I'm a parent. Because at that point, they're strangers to the child. When you sever...
Now, sit and think about that, right? There's a bunch of people on the internet saying courts are operating in presumptions. Well, this judge right here is telling you they're operating in presumptions. Plain out. I've actually had people call me out on the little things, and but my what do you call it? My what I've seen and went through, they've always went through presumptions.
Parent-child relationship. You now have these parents who are like somebody that's never met this kid. But we're saying, because you used to be a parent, that in and of itself gives you standing to come in and say, okay, I'm ready to parent again. And I know I've really gotten off in the weeds on that one, but in terms of just talking about consistency in the code and the way we're going to talk about parents and presumptions and best interest, that certainly is a, whoa, where did that come from issue.
Right. So we...
And there we go again. Interest. How did the state actually has interest in your offspring? A couple of videos back, we talked about a guy on a second kid found a gun, and he's looking at years in jail for picking up a gun he found and was mentally off a little bit, right? But he was still looking at jail time. And some of these things do get frustrating as heck. Okay?
Shouldn't muddy the water by, and I don't know if there's lots of case law about making a determination about what a fit parent is. Is there any case law or something? I don't believe there's any statute.
Oh, what I was going to say is like at 12 years old or something like that, once they're at a certain age, they are subjects to the state. Now, that being said, as soon as you go through this process and through the courts and CPS and custody battles, the offspring is still subject to the state. It's just earlier of age. The subject of to the state is willing to be into a higher courts. But in all actuality, family courts are treating the offspring as subjects of the state. And you know how I know? Because the mother, in most cases, okay, the mother is a witness. So who's the claimant? The state. And how did they become a claimant? Because they think the offspring is theirs. That is their subject. And that will give them standing.
I don't think there is either, and I think that also is a scary thing to try to legislate, and you gave the perfect example. I grew up in Houston, lived in Houston my whole life until I retired. I retired to Cold Spring, Texas, population less than 900. If a child in Cold Spring, Texas is walking to school half a mile, I'm going to say, well, okay. If you are in certain areas of Harris County and the testimony before the court is, this kid's gotta walk to school half a mile every day, there's a different part of the hair on the back of my neck that's standing up in that, and all of that sort of goes into best interest. But that doesn't mean the parent in Cold Spring is not fit. It means under the circumstances as they existed, they made a really good decision with regard to the kid. Same decision in Harris County might not be a really good decision with regard to the child.
I feel like what's being lost in this conversation, though, is the fact that the fitness of a parent is a presumption that's required by constitutional law. Is there case law? Yes, there's Supreme Court jurisprudence that says you must, as a court, as a matter of constitutional law, presume that the parent is fit. And then you may overcome that presumption with compelling evidence that shows that for whatever reason, decisions that the parent made that are so out of the ordinary or puts that child in such a dangerous position that, okay, this parent's not making the decisions that a fit parent would make. But we can't lose sight of the fact that we have to start with the presumption that every parent enjoys under the Constitution.
Okay, now they're kissing butt because that's not the way they do it in all actuality in court. All right, the courts actually look at both sides presumptions that they're unfit. So they're just playing the game of looking good. And I'm led to believe they're doing this because they are being recorded. And it would be a totally different conversation if they wasn't being recorded.
That they are presumed to be fit unless it can be proven otherwise.
I totally agree with him, and I just don't think that defining best interest will impact that. I completely agree with him that that's the presumption, and it's in a number of places in the family code.
Oh, great. So, if that's the case, then the presumption is both parents are fit. So, hit the gavel, 50-50 custody. You guys figure it out. Your attorneys figure it out, however you want to figure it out. But 50-50 automatically. Nobody's allowed to move from this jurisdiction unless agreed upon. These are We the People News. Bye, y'all.